Judgment in the matter of an application for judicial review by JR123.
Lord Sales will hand down the judgment.
This case is about the regime for the rehabilitation of offenders in Northern Ireland. The regime is set out in the Rehabilitation of Offenders Northern Ireland Order 1978, which tracked United Kingdom legislation in the Rehabilitation of Offenders Act 1974. Under the regime, convictions which carry a sentence of imprisonment of less than 30 months become spent after a certain period. When a conviction becomes spent, it means that the offender is entitled not to tell people about it when entering into contracts with them. It also means that state officials cannot take the spent conviction into account. The 30-month period is a bright line cut-off rule. For convictions carrying sentences of imprisonment longer than that, there is no possibility for the conviction to become spent. The offender remains subject to the general law to provide true information to those he contracts with, such as employers and insurance companies. That is so, even though it may be that the offender no longer represents a risk to society. The appellant is now aged 66. In 1980, when he was aged 21, he was convicted of arson and of possessing a petrol bomb in suspicious circumstances. He was sentenced to concurrent terms of imprisonment of 5 years and 4 years. He was released from prison in 1982. The appellant says he is now a fully rehabilitated member of society and expresses shame and regret for his offences. The respondent department does not dispute this. The problem for the appellant is that his convictions carried sentences of imprisonment well over the cut-off under the 1978 order, so that they can never become spent. He says that this has caused him various problems in his life and career. He found it hard to find employment when he told employers about his convictions. He also found it hard to obtain insurance when asked if he had any convictions. He has suffered distress and humiliation in circumstances where he has been constrained to reveal his convictions. The appellant maintains that the 1978 order is incompatible with his right to respect for his private and family life under Article 8 of the European Convention on Human Rights, as a disproportionate and unnecessary interference with his private life. His case is that in order to comply with Article 8, the rehabilitation regime must include a mechanism for any past offender to apply to have their case reviewed, and if they pose no current risk, to have their conviction treated as spent. He also claims damages for the humiliation and distress he has suffered in the past. The appellant was successful in the High Court in Northern Ireland in obtaining a declaration of incompatibility, but his claim for damages was dismissed. The department, which has policy responsibility for the 1978 order, appealed. The appellant cross-appealed on the damages issue. The Northern Ireland Court of Appeal allowed the department's appeal and dismissed the cross-appeal. The Court of Appeal considered that the application of the 1978 order with a bright line cut-off rule is compatible with the Article 8 rights of past offenders like the appellant. The appellant now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal, albeit for reasons which are in some respects different from those given by the Court of Appeal. There has been some development of the rehabilitation regime as it applies in England and Wales and in Scotland, but not yet in Northern Ireland. The category of convictions which can be treated as spent has been widened so that longer periods of imprisonment are now covered. The appellant admits that the changes in the other parts of the United Kingdom support his case that the 1978 order is incompatible with his rights under Article 8. The court reviews the development of the rehabilitation legislation across the United Kingdom and shows that in all the nations, the current regime still operates with a bright line rule scheme without the possibility of individual assessment, and that the appellant's convictions would not be treated as spent under those regimes. The 1974 Act and the 1978 Order were based on a careful assessment of the proposed regime in a report which was followed by Parliament. The Supreme Court holds that the margin of appreciation for the legislator in devising the rehabilitation regime was wide, and the legislative choice it made should be respected. The appellant's claim is better analysed as a claim that the state is under a positive obligation to intervene in relations between private individuals, namely the appellant and prospective employers and insurers. But whether it is analysed in that way, or in terms of a negative obligation on the state not to take action to interfere with his rights, the legislative regime is compatible with the appellant's Article 8 rights. The Court reviews the proper approach to an appeal on the issue of proportionality of a general measure like the 1978 order, and concludes that in a case like this, an appellate court should conduct a fresh assessment of that issue, rather than merely reviewing the judgment of the first instance court to see whether it had applied the right test and whether it had made any error. On the court's assessment, there are two legitimate aims for adopting the structure of the regime in the 1978 order. First, to protect the rights and freedoms of others, including potential employers, insurers, and the rights of other offenders to be treated according to a fair and consistent regime. And second, the prevention of disorder or crime, as a more restricted rehabilitation regime will be a deterrent to potential offenders. There is a wide margin of appreciation in this case for several reasons. First, it involves difficult questions of moral and political judgment. Second, there is no consensus on this issue amongst other countries who are parties to the Convention, nor in the different parts of the United Kingdom. Third, the order strikes a balance between competing private interests. Fourth, the type of individualised assessment regime for which the appellant contends would be burdensome and costly to operate. It would also be less fair and could potentially lead to inconsistent treatment of offenders in similar positions. Fifth, the order was the result of careful policy consideration in the report, which preceded the 1974 Act and in Parliament. Sixth, in terms of striking a fair balance, the appellant is responsible for the situation he finds himself in, having committed a serious offence. In the judgment, the Court also explains the proper approach to be adopted in relation to a claim for a declaration of incompatibility. Finally, because the Court dismisses the appellant's claim that his rights under Article 8 have been violated, it also dismisses his claim for damages.
Thank you.